see Mr. Dutton and Mr. Jackman. It appears you are in the courtroom, but I don't have your video or audio. There we go, Mr. Jackman. All right, we are ready to proceed. Mr. Jackman, the floor is yours.
May it please the court, my name is Xavier Jackman. I represent Bain Complete Wellness in this matter, and at this time I'd like to reserve the full 5 minutes for rebuttal.
Very good.
Members of the court, this is an appeal of an award of sanctions awarded by the lower court pursuant to Florida Statute Section 57.105. The issue regarding entitlement was that the demand letter set in a PIP case was found to be insufficient as a matter of law, and that the contents of the demand letter were untenable for legal defense. Therefore, the court found an award of sanctions based upon the demand letter. Further, other issues that I'm going to address today are the evidence presented at the fee hearing, as well as the award of costs pursuant to Florida Statute 57.105. One thing I did want to clear up prior to beginning was on my standard of review on my brief. I argued that it was a de novo standard. I believe that to be correct for a majority of the issues on appeal. However, when I was looking at this, I do want to clarify with the court that it is an abuse of discretion standard when it comes to award of fees and amount of hours. I apologize for misstating that in my brief. But going on to the standard of section for sanctions pursuant to Florida Statute Section 57.105 was recently espoused by Your Honors Judge Silverman and Judge Smith in the Schur versus Silverio or Silverio. I'm not exactly sure the pronunciation of that. In that decision, Your Honors stated, we recognize, however, that Section 57.105 must be applied with restraint to ensure that it serves its intended purpose of discouraging baseless claims without casting a chilling effect on the use of the courts. They further went on to cite the 4th DCA case of Minto versus 1,000 Friends. And it says, when there is an arguable basis in law and fact for a party's claim, a trial court may not sanction that party pursuant to Florida Statute Section 57.105. Again, as you're probably well aware, Judge Silverman, you wrote that order, and Judge Smith, you concurred. When we look at the basis that was stated for the sanctions in this matter, there are basically 3 or 4. It was a little confusing with the writing of the motions and the orders, but the initial one seemed to be that $10,000 was the most that could ever be sought in a PIP demand letter. That is a misinterpretation of Florida Statute 627-736 subsection 13, which provides a minimum benefit coverage. It does not provide a maximum benefit coverage. To quote, if the Financial Services Commission determines that the cost savings under personal injury protection insurance benefits paid by insurers have been realized due to the provisions of this act, prior legislative reforms or other factors, the commission may increase the minimum $10,000 benefit coverage requirement. And so the argument—
What about the policy? What about the policy cap?
The policy in this case actually did limit benefits to $10,000 of PIP benefits, and there was no med pay. However, we didn't find that out until a day before the hearing on the motion for sanctions, when that document was finally filed with the court.
I thought you were provided with documents that would put you and your client on notice of that.
There is no certified copy of the policy that was ever filed with the court. And that what they cite to in the record is a response or a request to produce, but the record shows exactly what was filed. It was the written document, but the documents that were supposedly attached were not attached. And if you look at the record, you'll see that they cite, when they say that the document was in fact produced prior, they cite to the record but the record shows that only written answers were provided and no documents were filed with the court.
Mr. Jackman, let me just follow up on that quickly, because having done some litigation myself, I kind of know how the discovery itself isn't filed in the record. But if there is some claim that the actual policy was served separately to counsel with the physical or electronic copy of the responses to the request to produce, was there anything in the record to that effect?
I don't have anything. I reviewed my records, Your Honor, and I went through to see if I had any documents attached. And my records do not show that any documents.
Well, hold on. I don't want to know. I don't want to know anything outside the record, because we're confined to the record. So,
Yes.
Okay. So was there, and this kind of goes either way. Was there any record evidence that, that you had it or that you didn't have it? And if there's not, there's none either way. I want to.
I'm sorry, I don't mean to interrupt.
No,
but
I think it's an important fact to know whether there was any record evidence that you had a physical copy of it, separate, of course, from the record.
I don't believe I did on this particular policy. I do have USAA and Garrison policies that I've received in different cases that I could utilize to determine, that I knew the basis of the terms and conditions of their policy. As for the declarations, there's
Garrison
nothing.
never put you on notice that the policy cap was $10,000 prior to you said the eve of the.
They made
sanctions hearing?
allegations. They made allegations, Your Honor, but they never provided any record evidence that the policy was in fact 10,000. No, it was not. The policy was not filed with the court until the day before the hearing on the sanctions.
Well, we just covered that, and Judge Smith was just drawing a distinction between what was filed with the court and what evidence might be in the record indicating that you or your client were made aware by the defendant that the policy cap was $10,000.
The only thing in these, anything that would happen after the sending of the demand letter. Remember, we have to look at this at the time the demand was sent. And I think it's important to remember that we have rural metro out there that tells us that a first party, a medical provider cannot get information, policy information from a first party insurer.
What if the defendant is happy to make you aware of policy information for the purpose of showing that your demand letter, well, and their argument is insufficient under the statute, but is also illustrative of the paucity of the merits of your claim, so to speak?
I asked for a copy of the policy in the demand letter, and they refused to provide it.
Mr. Jackman, I wanted to follow up on something you just said, because I think it's important when we're looking at this. So there's a safe harbor period of 21 days, right, after the motion is filed, and that safe harbor period closes. And if you take action, you take action. If not, then you risk if later down the road it's determined. And so when we are looking at this, from the standpoint of what was known or should have known at the time, we're looking at it from the standpoint of December 1st, 2016, when the motion for sanctions was filed.
Correct.
Okay. And so if I look at that from that standpoint, then I have to look at what was in the record before. And I think there's the motion for summary judgment was already filed. The affidavit was already filed along with that. And then I guess some requests, the responses to the request to produce. In that, was there any facts about what the policy minimum or maximum or the deck, like detailed facts, not the actual document, but was there any responses that would have put you on notice at that point in time?
There was an allegation contained in Mr. Briggs's affidavit that there was that the policy terms and conditions were what they were, and that had been previously filed with the court. It had not been previously filed with the court. He referenced a document that didn't exist. And so I don't believe that to be sufficient to establish as a matter of law, to the disregard of any tenable argument, that there was $10,000 coverage available. And even if there what, go ahead, I'm sorry, go ahead.
No, my next question is, as far as the actual, the proper insurer in this case, there's some, I guess, USAA and Garrison, even though you're getting items from USAA and USAA is giving the payments, the insurance company is actually not USAA who issued the policy, but it's Garrison. So at that point in time, was there, or later, was there any effort to rectify the demand, the pre-suit demand with the correct insurance company?
Well, if you read the response to the demand letter, and I believe that's records 133 and 134, it's the last 2 pages of Mr. Briggs's affidavit, he responds on USAA letterhead.
Right.
And in that letterhead, he said USAA made payments. And so there becomes a dichotomy, because we have them saying it's not the right insurance company, yet USAA is the one that made payments. And so, and the letters on USAA letterhead, all the EOBs are on USAA letterhead, and they're saying that USAA is the company that made payments. And I think that was really the line that raised
and
an
in that letter, do they disclose who the insurer is?
They say Garrison was the insurer, but then they say USAA made payment. So there's an ambiguity there, specifically regarding who they're claiming. Is there really a differentiation, or is this just the same company putting on a different hat? And I think there's case law out there regarding that. I believe I cited in my initial brief. I may not have. I don't know off the top of my head, but clearly,
I guess,
Mr.
are you
Briggs,
looking at, I'm trying to think, you're looking at which page of the record?
and when we're looking at the response to the demand letter, it's 133 and 134. It's the last 2 pages of the Briggs affidavit.
Okay, because the only thing that I see in that where they talk about the insurer is that they say the name of the correct insurer is listed on the insured's insurance card on the right up, or the upper left-hand corner. I don't know that they actually state Garrison.
Give me 1 sec. Yeah. There you go. Yes. So USA, but they say USAA made payment.
Okay. I just was trying to figure out if they had given you notice prior to the December 1st motion for sanctions that the insurer was actually Garrison and not USAA.
Anything would be contained in the demand response. There was no other communications regarding this claim that I'm aware of.
Okay.
Let me ask you this. So you mean Bain files a demand letter, wants to sue the insurer. Now, Bain is not in privity with either Garrison or USAA, right? Bain is an assignee of benefits of the insured. Should we presume that at all stages, it's the insurer's responsibility to inform you of what your assigned rights are? Or is it possible that we could look at it differently and presume that maybe it's the assignee who took assignment of benefits, presumably in lieu of payment? It's that entity's responsibility to know exactly what benefits it was assigned, which would require, or at least potentially be able to be effectuated by asking the assignor to provide a policy to observe, to look at that policy. Would have told you who the insurer was. That policy would have told you what kind of cap on benefits there might be. Why should it be the insurer's responsibility, who's being sued in a demand letter by a third party, to inform you of what your rights are under your assignment of benefits?
I don't know if they have any responsibility to do it, but I don't think you can hold it against the provider for that information not being, because it's specifically precluded under
what is specifically precluded?
Any policy information regarding first party insurer.
Right, you can't demand it of the insurer, but why can't you demand it of the insured with whom you're in contractual privity? That includes an assignment of benefits under a contract with a third party. You can't ask the party from whom you were assigned benefits to, hey, shoot me a copy of the policy or your insurance card so I even know who the actual insurer is?
I think in certain situations that is possible. It's not going to be possible across the board, and it shouldn't. I don't believe it should be the policy of the state of Florida to require that. Especially
no,
in
it's not.
situations.
That's not a policy of the state of Florida. It's just
Yeah.
we're trying to determine what seems to be at issue here is there's one could perceive of Bain's decisions with regard to their demand letter and going forward with the suit as either, I mean, I'm just going to be frank here, intentionally obtuse, or one could think, well, they were being kept in the dark by an insurer who didn't want to provide enough information, or let's say perhaps a factor in determining whether of those two instances were the actual case, intentionally obtuse, being kept in the dark. One could think of the facts and one could draw reasonable inferences that if a party, in lieu of payment, accepts assignment of benefits, that party would probably have an interest in knowing what benefits it was assigned. And they could get that from the assignor just as easily as they could get that from the third party contracting party.
A couple of things, Your Honor. Once we got the assignment, we did request the insurance policy, and it was denied. Secondly,
denied by whom? Bain?
By
your
the
client?
by
The insured?
The insurer. The insurer.
Well, why didn't you ask for the policy from the insured?
We did not ask for the policy from the insured. It's the purpose of the PIP statute is a swift and virtually automatic payment. The most efficient method to get this policy is through the insurer. You take the assignment, you believe you have all rights and privileges that the insured had, but yet when you go and request a copy of the policy, they say, no, we're not going to give it to you because you're a first party medical provider and we stand on rural metro. So they kind of have it both ways. They say, without an assignment, we don't give it to you for rural metro, but then you have an assignment and they still fall back to rural metro. So it does provide some problems. Number two, there's situations where there's omnibus insurance. I mean, there's people that, especially with PIP, I mean, you don't even need to be in the car. You don't even need to know this person to have that policy cover you for a loss. It just needs to be related to the use and maintenance of an automobile. So if you get hit on the side of the road in a bicycle, you are going to recover PIP through the driver's policy. And so the idea that that person who's sitting in a hospital with multiple broken bones is going to be able to garner that information, even if I'm not quite sure for an omnibus insured, even if they would have privy to that information. So,
Mr. Jackman, let me just let you know you've gone beyond the 5 minutes. If you want to reserve your 5 for rebuttal, I'll go ahead and let you do that.
Yeah, I'll just take a couple minutes, Your Honor, if I can just move on real quick.
Yep.
I think you guys saw when if the court determines that the award was justified, when we got to the fee hearing, I never got time slips despite us repeatedly requesting them. Again, much like the policy, it was provided the day before the hearing. Mr. Dutton apparently at the hearing tried to claim that the affidavit of the expert served as producing time slips. That I don't believe is sufficient. The expert specifically stated that he got some information from Mr. Dutton. He copied and pasted it into a new document, and that was the document that was provided to us. Obviously, that doesn't satisfy the requirement of providing the time slips prior to fee hearing. There was a summary of the time slips used by Mr. Dutton. There was no announcement that a summary is going to be used. And like I said, the time slips were never produced. As such, the summary should not be accepted as evidence. Real quick, there was some cases that were entered into evidence. There was no motion for judicial notice made for these cases. They were all entered into evidence. I made motions for judicial notice for cases from the court that were apparently excluded. So I'll just reserve the rest of my time for rebuttal.
Very good. Mr. Jackman, you'll have 3 minutes for rebuttal. Mr. Dutton, you may proceed.
Thank you, Your Honor. And because the court was concerned about it, my name is Scott Dutton. I represent Gears. And so let me sort of build this from the ground up, particularly regarding the court's concern, and particularly yours, Judge Smith, about what they knew or when they knew it. Let's start with the response to the pre-suit demand. And so we sort of jumped over exactly what's on the face of 133. So let me tell you that letter in response to the pre-suit demand that he's talking about was part of the affidavit served by the claims adjuster in the case, Mr. Briggs. And it is Exhibit D. And what it says, and let me read it to the court if I may. Number one, the correspondence is invalid because it has identified an insurer that did not issue the insurance contract. The name of the correct insurer is listed on the insured's insurance card and on the upper left-hand corner of the explanation of reimbursement. Now, part of that affidavit, all the way through, are the explanations of reimbursement, multiple ones. And if you go to any one of them, let's say for record 123, up in the upper left-hand corner, just like it told Bain, look, and it says company, Garrison Property and Casualty Insurance Company. And that's because USAA is just a logo. It's not a company. In fact, the only thing that would be even close to it would be United Services Automobile Association, which is an insurance reciprocal. It's not even a company. But be that as it may, they're told that to look at the insurance card. Now, we're not going to dive into what sort of information that Bain receives as the provider each time it sees a new patient. But one of the things they normally see is the insurance card that says who the insurer is and also what the policy is.
Let me ask you this, Mr. Dutton. The as far as any payments that Bain received, were those issued by USAA?
They're issued by Garrison. They're all different risk pools. And if the drafts were here part of the record,
Well, let me
Garrison on it. It says
okay,
Garrison.
so yeah, let me ask it this way, because I think I'm correct that I have to be looking at, and we have to be looking at December 1st, 2016 at when the motion was filed, not
It's
later.
actually, there is a later date. There's also, I believe it's April of 2017, but we can come back to it, Your Honor. I interrupted you. My apologies.
Okay. What is the later date? Was there a second motion?
April 11, 2017.
That's right. Okay.
That's the actual date that I believe the court traveled upon as well, that particular date.
Okay. And that's the second motion. So I'm looking at the EORs and I'm trying to match these up with the PIP log, that the ledger that was done. So if I add up all the PIP allocated line items and I add those up, I don't come to the 10,000 on the PIP log. And so my question is, you know, in the course of discovery, parties aren't supposed to just accept what the other party provides them, but perhaps maybe educate me. Am I wrong in that the calculations don't match?
I think if you look at Exhibit B, which page 126 of the record, and the payment ledger and amount at the bottom says 10,000. And that would be real important, quite frankly, if we were here on the benefits exhausted, which his case had benefits exhausted as well. And that's why the Briggs affidavit is there.
Okay, but see, you're highlighting my point, I guess, which is that payment ledger is from, I don't know, is it from USAA or is it from Garrison? One of the two.
It's from Garrison.
Okay.
From Garrison. Garrison didn't insure this person.
But
I mean, USA didn't insure this person.
Sure. But the EORs that are attached to the affidavit, if I calculate, there's a line item that says PIP allocated. If I add all of those up, I don't get anywhere close to the 10,000 on the payment ledger. And so I want to be very careful in looking at this as to what they knew. So shouldn't those match?
No. And because they're not, I don't believe they're each and every single service provider. But again, if we were here in a exhaustion case and following the court's point, but as it relates to what the correct insurer is in this case, every single explanation of review shows the correct insurer in the upper left-hand corner.
Well, you're also
Okay.
talking about the cap, and you digress back to the name of the insurer. I can't speak for Judge Smith, but I think one of the things she's getting at is that one of the arguments that the demand letter was insufficient is that are the numbers. You know, in other words, it was a $30,000 demand, and so does it matter that whether there was exhaustion if the demand exceeded the $10,000 cap?
Yes. The reason is because you can't, no matter what, you can't. I should have started with, this is a PIP case. And despite there may be some exception to it that was alluded to by Attorney Jack, nevertheless, PIP only has $10,000 in coverage. You may have some other types of coverage that may be available, which was not available here, but it wouldn't be under PIP coverage. You can only get $10,000 in PIP coverage. In fact, if I may, returning back to that response letter, page 133, Mr. Briggs goes on to explain, please be advised that USAA has paid a total of $10,000 in benefits and that the personal injury protection benefits for this patient they claim have been exhausted. So it tells them what the policy limits is there, but it also tells them in the affidavit itself. And if you look at the affidavit of
Mr. Dutton, well, one, it is a little, I have to admit, it's a little confusing for you to say that USAA is just a logo, but in the letter, in the response to the demand, they're advising them that USAA has paid all the payments, which you just told me Garrison did. So I'm a bit confused. But then to my other point, which, you know, is concerning to me, is that if, you know, litigants aren't supposed to necessarily take the other side's documents at face value and say, oh, you say it's this, therefore, you know, I don't need to do any discovery. And at this point in time, can you tell me in the record, was the other side provided with a certified copy of the policy that would have showed these limits?
That was going to be the second point I was making. But before I just leave this packet of Mr. Briggs, I did want to point out that in the front, there's the payment ledger, page 141, but more importantly, the second document, look at the record page 142. There's a declarations page. And the declarations page is the declaration of coverage. In the upper left-hand corner where it says Garrison Property and Casualty Insurance Company. And then on down, it actually talks about the specific policy limits for personal injury protection. I did want to underscore that because it lists the $10,000 there, again, on page 142 of the record. But
so we're all straight. So when was that provided to the plaintiff?
November 18, 2016. USA was doing everything it could to tell Bain, you need to dismiss this case. You need to dismiss it because benefits are exhausted. And later you need to dismiss it. It's in the affirmative defenses. You need to dismiss this because you haven't named the right insurer and that your pre-suit demand exceeds the available policy limits. But I do want to get to the point that you made, Judge Smith, and that is in the response to request to produce. And if you would look specifically at page 56 of the record, you will see, question, or request a certified copy of the insurance policy, including all applicable endorsements, the complete application and declarations page that was issued by the defendant, which affords coverage and has been claimed by plaintiff to afford coverage to Carrie McDougal. Response: a certified copy of the policy and declarations is attached.
But it didn't make it in the record in that attachment because I didn't see it to the back of that.
It wouldn't, because obviously it would be, if you will, when we produce documents, as the courts are alluded to, you did litigation.
Well, and we would put that a separate copy is being served via a separate manner, not that it was actually attached. So, I mean, there was probably a better way to have said that.
Yeah, and so what normally happens these days is that it's served this electronic copy and the response request produced, and the actual documents that are going to be provided are provided in separate form. That's normally how it's done. In this case, it was done. And if it wasn't done, that is never, ever in any of the motion practice that we didn't receive the policy that you say we received in the response to request to produce. That's not part of any motion practice here before the court. Moreover, and again, I do want to circle back to the affidavit of Mr. Briggs for not only that reason, but in his affidavit, Mr. Briggs specifically states that the policy has only $10,000 worth of coverage, of PIP coverage, and that is also significant as it relates to this particular matter. So we're looking at several times over where they're told, they're shown before the suit is filed, they're shown when suit is filed by the vis-a-vis the DOBs, vis-a-vis the certified copy of the policy.
You filed two. Sorry to interrupt you, but we actually, let me let you finish, because this has been a point of contention. So please finish. Go ahead.
No. So on multiple occasions, long before the motion for sanctions was filed, as it relates to the invalid pre-suit demand, they were put on notice of they served it against the wrong insurer, because the statute specifically requires a couple of things. Number one, must be provided to the insurer, and USAA, despite the fact it's local, is not an insurer. But number two, that they were advised that it was the wrong insurer. And then it gets to specify the amount claimed to be due. And this is a PIP claim. Again, it's not a claim for—
Let me ask you this. So let me interject then my point here. You filed two motions for sanctions, or you at least asserted two grounds, right? One was that this two arguments, and perhaps two motions, I forget, but that maybe that's what y'all were talking about earlier, two motions, but two arguments for why the claim was not supported by the merits by the law or the facts. Now, one of the arguments is that the condition precedent of a demand letter was insufficient. The other one was that the claim itself lacked merit, correct? I mean, in other words, there was no one, you could not have been possibly entitled to what they were what they were seeking.
It's a $10,000 PIP. Yes, sir. And,
yeah.
in fact,
so in other words, so before we get to that latter, that other ground for 57.105.1 sanctions, let's talk about the ground that it seems the court latched onto and asserted as the basis. Now, the demand letter, was the demand letter insufficient? So the demand letter says, the statute says you need to itemize this, an itemized statement specifying each exact amount, the data treatment, service, and accommodation, the type of benefit claim to do. You know, the purpose is to put you on notice of what they're demanding. They could say, you know, I want $1 million in, massage therapy. I'm a massage therapist. I was assigned benefits, and I was assigned the benefits of the insurance policy, and I provided this, this insured with $1 million worth of massages. Now, doesn't that satisfy the notice? I mean, you're on notice. The type of benefit claim to be due. I'm claiming that I'm claiming PIP benefits for $1 million. That may not be meritorious, but based on your argument that the condition precedent hasn't been satisfied, why is that argument prevailing if you're fully on notice. I itemized all the times that the insured came in to get a massage, and it added up to $1 million. That's what I want.
And so let me say, with all due respect, it's been repeatedly addressed by the appellate courts to include, before the second district was taking appeals of PIP cases directly from the trial courts. There was an appellate case directly from the 13th Judicial Circuit. And it addressed that when you're submitting a pre-suit demand, that there is strict compliance with the statute. And when the strict compliance with the statute requires the specificity of the final amount claimed to be due, quoting, and I'm looking at Chambers Medical Group as assignee of St. Hilaire versus Progressive. It's at 14 FLW sub 207. And it's an old case from the 13th Judicial Circuit appellate from 2006. It says, we conclude that strict compliance with the notice requirement is required to effectuate the purpose of the statute. And what it's talking about specifically is that they have to enumerate the final compliance. And it says inaccurate, misleading, illegible, or stale information contained in a demand does not strictly comply with the statutory requirements. That was also addressed by the 4th District Court of Appeal in a case called MRI Associates of America LLC versus State Farm back in 2011. That's 61 Southern 3rd 462. And I'm going to go to the next case after that, which wasn't there at the time, but the 3rd districts looked exactly at this issue, and that is what specificity is required. And when the 3rd district looked at it, this is the case of Rivera versus State Farm Mutual Automobile Insurance Company. It's 317 Southern 3rd 197 from February of 2021, and we quote from it extensively. It talks about the precision that's required in the demand letter to itemize, specify the exact amount claimed to be due. So it disallows them to just put anything in there. It wouldn't.
But does it allow, I don't think you're answering my question, actually. Does it allow them to list the specific amount claimed to be due? And if your only argument that the demand letter is insufficient under the statute is that you don't believe that under the policy or under the statutes governing PIP policies, that amount is, that the insurance company is liable for that amount, how does that fail to satisfy even what you just described from those cases, that the specific amount claimed to be due, to quote the statute, has been set forth in the demand letter?
Well, this is what the statute says. It says that notice must state that it is demand letter under 627.736 and state with specificity. Then it goes down and says an itemized statement specifying each exact amount. And then it goes on to talk about the date of treatment, service, or accommodation, and the type of benefit claimed to be due. That would open up that would defeat the purpose of the pre-suit demand statute, because it completely lacks the specificity as required by.
Let me understand your argument though, and the argument that was convincing to the trial court about the insufficiency of the demand letter. My understanding of the argument, and you can tell me whether at present I'm forgetting other aspects of your argument, which is totally possible, but it is that because the policy, presuming the policy was capped at $10,000, that it cannot possibly be the case that the insurer is liable for the approximately $30,000 claimed to be due.
And that's
is there any other argument as to why that the demand letter does not satisfy the specificity requirement?
Yes. They also attach the billing ledger to it. And that if you look at the billing ledger is itself intrinsically inconsistent with the amount that they put in the demand as claiming to be due.
Yeah, okay. So in other words, I said, well, we want $1 million in massage services, and their billing ledger, didn't add up to $1 million.
No,
so that somehow doesn't specifically specify an exact amount that they claim to be due. They attached the attached documentation.
But 2 points to that, Judge Atkinson. Number one is it also exceeds $10,000. And number two is, and all of the appellate case law on this, it leads to a misleading result. It also doesn't take into consideration something Judge Smith pointed out earlier, is all the payments that were given to Bain, which the appellate case law also says it has to take into those considerations. So the point is that the purpose of the pre-suit demand statute is to put an insurer on, if you will, a last chance notice to pay the amount that is.
So let me ask you that. I know the purpose and that's stated in the case law. Aren't you on notice if a plaintiff assignee says, I gave $1 million worth of massages and I think I'm entitled to every penny of it? Aren't you sufficiently on notice about whether to pay that or whether to go to trial? I know what you're seeking. You said it specifically, and maybe your documentation adds up to 990 thousand, and you're missing, a bunch of receipts, or the payment ledgers. It doesn't comport with the amount demanded. But you're on notice. You said, well, you're seeking what appears to us as the insurance company to be a frivolous claim. We're not liable, so we're on notice. We can decide we're going to defend. We're not going to pay.
And again,
Mr.
it's
Dutton,
not the
just
amount.
before you answer, Mr.
Again,
Dutton,
it's not the amount. Go ahead.
Mr.
I'm
Dutton,
sorry.
before you answer, we're at the end of your time, but go ahead and answer the question. Absent more questions by the panel, we'll turn it back over to Mr. Jackman, but go ahead.
And Judge Axe, you bring up a great point about litigation. The purpose of the pre-suit demand statute is specifically to avoid litigation, to give the insurer that last chance in order to pay a specified amount, which is actually due. And so I guess I should have pointed that out, which is actually due under the law. And in this case, $35,000, or if you look at the letter, $27,000 is not due under the law. And with that, I certainly want to appreciate that and ask the court to affirm the court, and that these cases cannot continue to be brought when there's only $10,000 of PIP benefits and the pre-suit demand doesn't specify and doesn't provide the exact amount due, Your Honors. Thank you so much.
Very good. Thank you, Mr. Dutton. Mr. Jackman, I had you down for 3 minutes, but I'll give you an extra one. So you've got 4 minutes for your rebuttal.
Mr. Jackman, real quick, could you just answer me with something really quickly, and then I'll and now that I've already derailed your thought, there were two grounds listed. They're asserted. Now the trial court based its 57105 entitlement finding on the ground that the pre-suit demand letter was insufficient. There was an asserted ground, which is that not only was your pre-suit demand letter deficient, but your whole case is deficient. And you were served with a motion that said that's also grounds that your entire case, even if your pre-suit demand letter was sufficient, your case is not supported by the law and the facts. Could we affirm based on that as a tipsy coachman argument?
You could, as a tipsy coachman argument. It's not true. The case, the pleading was fine. It identified the provider. It identified the dates of service. It identified bills that were sent. It's identified that the bills weren't paid as sent. And like the prime
at the time you were served with the 5705 motion that said your actual cause of action is not supported by the law and the facts. Couldn't we infer that at that time you knew that even if the demand letter was just fine and dandy, that there was no entitlement to anything over $10,000? And that perhaps that $10,000 itself was extinguished by payments?
I think we need to get a quick little procedural history real quick. We talk about this affidavit of Dennis Briggs. I tried to set his deposition and they refused to show up. And then they filed a motion for protective order, and I was never allowed to even talk to Mr. Briggs. And so we're relying on this affidavit, and I was never allowed to cross that affidavit. They made, we had a hearing regarding the protective order. The judge said we could go ahead with the demand letter without any depositions or any further discovery regarding Mr. Briggs. But if we wanted to talk about that $10,000, they'd have to sit him for deposition. So I don't know if that answers your question. Is that what you were looking for? I mean, I'm trying to.
And you voluntarily dismissed.
I voluntarily dismissed when we got the policy. As soon as we got the certified copy of the policy, we dismissed.
Mr. Jackman, I want to ask one question that has been puzzling me. The demand letter was in a significant amount over $10,000. The actual complaint that was filed, and the trial court noted this in the order, the complaint is undue and overdue personal injury PIP benefits and interest in an amount less than $99. That's a pretty big discrepancy from the demand letter as well.
Correct.
So how do you explain that?
It's the demand process working, Your Honor. It is us identifying that there's issues that preclude us recovering the full 36. The full 36, the reasons it's demanded is because both medical payment coverage and PIP coverage both require a demand letter. It's in the insurer's best interest that we include this all in one demand letter so they don't pay PIP and not pay MedPay, because it goes to person C for MedPay and person B for PIP, and it creates a confession of judgment situation. So you include both, and that's what, if you look at the demand letter, it's a demand for PIP and MedPay, because we don't know if there's MedPay coverage, because like I said earlier regarding rural metro and the difficulties receiving this information prior to getting your demand out. Real quick, Mr. Dutton said payments were made by Garrison. There's absolutely nothing in the record regarding that. MRI Associates does not stand for strict compliance. It's actually, the language is very clear. It talks about substantial compliance. I'll quote from that case. The claim, first it refers to how the claim must be submitted. It says the claim must be submitted on a standardized form, properly completed pursuant to Florida Statute 627, 736, 5D. An insured is not required to pay the bill. I'm sorry, go ahead.
Yeah, Mr. Jackman, let me ask you, as far as the statute, does the statute, what documentary evidence does the statute require that you submit with the pre-suit demand?
With the assignment of benefits and a ledger or other document identifying the treatment, the amount charged for the treatment, the date of the treatment, and the provider.
Okay.
Mr. Jackman, we're at the end of the time. Take 15 seconds with your conclusion, please.
Thank you, Your Honor. Again, we're here on a motion for sanctions. We've had lively debate about the propriety of this demand letter. We've had arguments on both sides. My argument is not that the demand letter was sufficient, only that my arguments regarding the demand letter were tenable. We're not here to determine whether the demand letter is sufficient or not. The question presented to the court is whether or not my arguments were so devoid of law and fact that they were non-meritorious. I believe the Schur versus Severio cases that two of you were on would I certainly have raised at the very least a tenuous claim. I believe personally that the demand letter is fine. But certainly the arguments presented throughout this entire litigation are valid legal arguments. They're not made up. They're not frivolous. They're based on fact. They're based on confusion. They're based on the information that we had available to us at the time. And I would respectfully request the court overturn the amount of sanctions. And thank you guys for your time. My first time doing this, so I appreciate you guys. If there's anything further from me, let me know.
Very good. Thank you, Mr. Jackman, and thank you, Mr. Dutton. The final case on the docket is the